Good afternoon to everyone. My name is Rohan Kumar, and I welcome you all in the semi-final round of first Lex Explorer National Moot Court competition organized by Lex Explorer Legal Journal. For the very first, I would like to introduce our honorable judges of this round. Honorable judges of this round are Dr. Vaisali Arora and Divesh Kumar. We are delighted to have you both. Now, I would like to welcome our both the teams for the semi-final round. We are delighted to have such a wonderful mooters here. Today, we have with us team code 41 from the side of petitioner and the team code 52 from the side of respondent. Each team shall be allotted a total time of 40 minutes, out of which each speaker can take maximum of 20 minutes and only, and 5 minutes may be allotted for rebuttal and sur-rebuttal. The speaker of both the teams will be notified in the chat box where the 2 minutes are left for each speaker to indicate the time. Since both the teams and judges have joined with us, now I declare the court is in session. Let the speaker one of the petitioner side plead, followed by speaker two.
Yes, Your Lordship. Am I audible?
Yes, you are.
Yes. Honorable greetings to the bench. May I please the court?
Absolutely.
With the kind consent of the leadership, may the council address the bench collectively as Your Lordships.
Sure.
Much obliged, Your Lordship. The council is deeply honored at the opportunity to present the petitioner in the case of Chotilal Kumar versus the Union of India. Your Lordship, the council will deal with the opening statement along with the first and second issue, whereas my co-counsel will deal with the third and fourth issue respectively, along with the closing statement. Now, talking about the misuse of dowry laws, no one can deny the fact that laws against dowry are very strict and it is very difficult for the opposite party to prove that no dowry was ever demanded. Rather, it is effortless for the complainant to prove the demand for the dowry was by providing fake bills and photographs and videos of marriage. Now, the Delhi High Court has laid down various guidelines for the Delhi police during the investigation of dowry related complaints, observing that many women have misused dowry laws to settle scores with their husbands. Now, without taking much time of the court, I'll briefly mention the most important facts of the case in a sequential timeline manner so as for the better understanding of everyone. Now, talking about the 1st January 2020, it was that date when both Kiran Kumari and Mr. Chotilal got married and that marriage was solemnized. Now, 21st January 2020 was the day when Kiran Kumari returned home as Chotilal asked for 20 lakhs rupees. Again, moving forward with the 5th August 2020, Chotilal left her at her parents' house, and after a few days, she came back and Chotilal got her, apologized, and got her back to his place. On 10th September 2022, which is 2 years later, Kiran came home and said Chotilal was asking for another 6 lakhs rupees, and this is when her father, a renowned politician of the country, gave away 30 lakhs rupees. Finally, on the 15th October 2022, after 2 years of their marriage, Kiran committed suicide. If your lordships are pleased, may I be permitted to move forward towards the first issue?
Please carry on.
Much obliged, lordship. In the very case of Tirupati Balaji Developers Private Limited versus the state of Bihar, which happens to be a special leave petition with the civil number 2004 of 2002, the court observed that the article of 136 happens to be an extraordinary jurisdiction vested by the constitution and the Supreme Court with implicit trust and faith, and extraordinary care and caution have to be observed in the exercise of such jurisdiction. The court further observed that the Article 136 does not confer a right of appeal on a party, but rather vests a vast discretion on the part of the Supreme Court, meant to be exercised on the consideration of justice and eradicating injustice. It is humbly further submitted that the present case is suitable for the Supreme Court to interfere in the findings of the Honorable High Court and the Learned Trial Court to negate the rights of the parties. Now, the Honorable Supreme Court in the case of Dalbir Kaur and others versus the state of Punjab, which happens to be a cited case of 1977 AIR 472 page number, framed some guidelines which I will submit right now. The first guideline that they mention is that the Supreme Court must not interfere with the findings of facts, even if the Supreme Court has different views of the evidence. But the second, third, and fourth citations are very essential in our case. Now, the second important point that we'll talk about is that the Supreme Court will not review the evidence unless the High Court has made an error in the process of law. The third one being that the Supreme Court will interfere in case where the High Court has violated the principles of natural justice or has acted in violation of the provisions of the law. And lastly, that the Supreme Court must also interfere in cases where the High Court has interfered wrong conclusions from the evidence. In the aforementioned case, the SLP filed with the appellant was accepted and his conviction was set aside. Now, further moving forward in the case of Radha Mohan Singh, Lal Sahib versus the state of Uttar Pradesh, which happens to be a criminal appeal, from 1183 to 1185 of 2004, that reappreciation of evidence is permissible only if an error of law or procedure and conclusion has arrived as purpose. Now, therefore, it is a common principle that through Article 136, it is couched in the widest terms. The practice of this, the court is not to interfere on the questions of fact, except in exceptional cases when the finding is such that it shocks the conscience of the court. Now, again, moving forward with another case, that is in the case of Hemchand versus the state of Haryana, with the citation AIR 1995 Supreme Court, page number 120, the judgment of similar circumstances were appeal filed by the sole accused in the case against the judgment of the High Court of Punjab and Haryana, confirming that the conviction of the appellant under section 304B and 498A of the IPC and the sentence of imprisonment for life and 2 years respectively awarded the thereunder by the trial court, and the special leave petition was accepted by the Supreme Court. Further, it is humbly submitted that the present case, the learned trial court and the Honorable High Court had not appreciated the evidence of alibi that was given by the appellant, and hence the courts have ignored a very important and relevant piece of information that had led to the violation of natural justice, fairness, and equity, and hence it is evident that this special circumstances exist which makes the appeal eligible to be accepted by this Honorable Court. Respected Justice of the Honorable Supreme Court, now may the Council be permitted to proceed towards the second issue. Much obliged, Your Ladyship. It is for Your Ladyship, I will be elucidating the further submissions about how there is a substantial question of law with respect to the evidentiary value of the diary entry and the dying declaration. So in the subsequent issue, I will be mentioning this thing, how the Honorable Trial Court and the High Court failed to take the essentials of law with regards to the evidentiary value of the diary entry as well as the evidentiary value of the alibi. This is a substantial question of law because it does have impact over the decision of the matter. It has rather substantial amount of impact over the final decision over this court, which is to be arrived at by this court. And there are many questions of law that has not been considered by the learned trial court and the Honorable High Court. So therefore, this particular special leave petition is maintainable in this Honorable Court. This is because the petition is not allowed, and it would lead to the miscarriage of justice, Your Honor. And as to secure the aims of justice, this petition ought to be taken with consideration by the Honorable Court by using its discretionary power, Your Ladyship. It is not a declaration per se, because when the victim was writing the entry in her diary, she was not in a stable state of mind. As per the facts, there has not been any written fact that she committed suicide because of the claims of Mr. Chotilal with respect to the dowry. And secondly, there were no signs mentioning that this was claimed to be a dying declaration, Your Honor. Further moving, there are certain essentials that are needed to be fulfilled when we're talking about a manuscript, near dying entry to be considered as a dying declaration, Your Honor. The first one being that the person who committed the suicide needs to be on a deathbed, which was not the very case in here. It was just a diary that she used to write every single day, jot down her feelings every single day, a person who loves journaling. There are no needs to be there happens to be no apprehension of a death. And in all possibility, the death should be an ultimatum, the ultimate outcome, which was not also in this very case. Hence, the two essential factors for it to be called as a dying declaration was not fulfilled. Again, it is not very clear when the diary entry was written. The dates as such are not mentioned in the diary. Now, moving forward with the second issue, I would like to cite a few cases. Before that, it is humbly submitted that the Section 32, Clause 1 of the Indian Evidence Act defines dying declaration as when the statement is made by the person as the cause of his or her death, or under any of the circumstances of the transaction which resulted to the loss of their life, and in cases where the cause of the person's death comes into question, Your Honor. However, it is not the rule that all such statements to be accepted by the court as dying declaration. To cite a few cases, the first one being Ramnath versus the state of Madhya Pradesh, with the citation as AIR 1953 Supreme Court 420 page number, the Supreme Court stated that it is a well settled law that it is not safe to convict an accused person merely on the evidence furnished by a dying declaration without further corroboration, because such a statement is not made on oath and is not subject to cross examination, Your Honor. And because also the maker of it might be mentally as well as physically in a state of confusion, and might well be drawing upon his or her imagination while making those declarations, Your Honor. Further, to cite another case to back up my statements, in the case of Parambaka Rosama versus the state of Andhra Pradesh, which is a case of 1999, 7 SCC 695 page number. In this case, the deceased had received extensive burn injuries to the extent of about 90%. The prosecution case solely rested the case on the values of their dying declaration. It was observed that it was necessary to ensure that the statement was genuine and it was recorded when the injured was in the fit state of mind. The certificate, which was appended by the doctor at the end of the dying declaration, was that the injured was conscious at the time of recording of her statement, and there was no certificate to the effect that she was in a fit state of mind to make the statement, Your Honor. It had been also held that without a medical certificate about the mental fitness of the maker of the dying declaration, it would be very, very risky to accept the said manuscript. Further, moving forward with another case that I would like to cite, in the case of Lakshmi versus Om Prakash, which is a 2001 case, 6 SCC, page number 118, the court there depreciated the practice of the police officer recording the dying declaration, except when the condition of the deceased was so precarious that no other alternative was left. The dying declaration is supposed to be recorded by the magistrate, which is also futile in this situation. Further, in the case of Ramila Ben versus the state of Gujarat, with the citation as AIR 2002, Supreme Court page number 2996, the court further stated that a dying declaration is generally to be recorded by an executive magistrate with the certificate of a medical doctor about the mental fitness of the declarant to make the statement. It may be the form of question and answer, and the answers are written in the words of the person making the declaration, which are the three essentials not fulfilled in this very case. Honorable Justice, the council wants to bring your kind attention to the fact that in the present case, the alleged dying declaration of the deceased had not been recorded by a competent magistrate in the proper manner. That is to say that the procedure of admission of a dying declaration had not been done according to the law. Again, the prosecution also has failed to establish the mental state of the respondent has also failed to establish the mental state of the deceased, and the deceased was fit to make such a statement while making the same. The prosecution has blatantly mistaken a written diary, a written journal that a person used to maintain every single day to be a dying declaration in a court of law that has not been recorded in a proper manner as emphasized in the law. Further, we question the state of mind of the deceased while she was writing the contents of the diary. Is there any proof of or mental certificate indicating that she was in a fit state of mind and the contents are not a result of her imagination? I'm not really sure about that. We'll move forward with the case. Now, the petitioners give us a reason to believe that the facts stated had not been impaired at the time she was making the statement by circumstances beyond her control. Further moving, can the petitioners give us a reason to believe that the statements written in the diary have been consistent throughout the several opportunities of making a dying declaration apart from the official record of it? There is no official record of any such statement. Finally, can the appellants give us a reason to believe that the statement had been made at the earliest opportunity and was not the result of tutoring by interested parties? Well, with this, I rest my second issue. Now, my co-counsel will move forward with the third and fourth issue.
Counsel, I have some questions. I would like to ask the organizers if this is the appropriate time to pose the questions.
Yes, ma'am.
Okay. So, Counsel, my first question to you is that in the Indian scenario, Is the expectancy of death or the fear of death is necessary as far as dying declaration is concerned? Would it be admissible only if there is an expectancy of death or a fear of death?
Yes, Your Lordship, because this happens to be an essential element for the same.
Okay, my second question to you is, you were talking about corroboration, but can you move on with the dying declaration without corroboration also?
No, Your Lordship.
Are you sure?
Yes, Your Lordship, it cannot be.
Okay, so my last question to you is it necessary that the dying declaration must have been recorded by the magistrate or by the police officer?
Your Lordship, for it to be admissible in the court of law, there are certain essential elements that I mentioned in my case. That is,
Hmm.
it needs to be in, like, for it to be um, the ultimatum in front of the court, it needs to be done in front of the magistrate so as to make sure that the proofs submitted are the truth to the best of their knowledge. That is the reason why in front of magistrate it is always considered to be the absolute necessity.
All right, I think we can move on with the next issue.
Yes, Your Lordship, my co-counsel will move further with it.
If the judges are fully satisfied with the present issue, counsel wants to move forward with issue third.
Okay, proceed with.
It is humbly submitted before the Honorable Supreme Court that the judgment given by the learned trial court and the Honorable High Court should be considered erroneous. They considered only dying declaration and did not look into the factor of plea of alibi taken by the petitioner. It is humbly submitted that the dying declaration cannot be considered as like that the diary cannot be considered as a dying declaration. It is humbly submitted before the Honorable Supreme Court that the admissibility of the diary written by the deceased as a dying declaration is already challenged under issue second by my co-counsel. But I would like to cite few more cases as per the precedent established by the Supreme Court in the case of State of UP versus Ram Sagar Yadav, cited as AIR 1985 SC 416. It was observed that the primary effort of the court is to find out whether the dying declaration is true. If it is no question of corroboration arises, it is only if the circumstances surrounding the dying declaration are not clear or convincing, then the court may, for its assurance, look for corroboration to the dying declaration. In the present case, the diary written by the deceased only mentions about the demands made which does not conclude the cause of death of the deceased. I would like to mention that as per section 32 of IPC defines when the statement is made by the person as the cause of his death or as any of the circumstances of the transactions which resulted into the loss of life in cases in which the cause of that person's death come into the question. The diary recovered by the police during investigation cannot be considered as a dying declaration and it does not fulfill the essential requirement under section 32 of the IPC. I would like to cite one more case of Nalamveera, Satyandam and others versus High Court of Andhra Pradesh, cited as 2004-10 SCC 769. Presumption under section 113B of Indian Evidence Act is available to the prosecution. First, dying declaration is accepted, and secondly, presumption stands rebutted. Unless the prosecution is able to establish that the cause of death was not accidental by evidence other than the dying declarations, the prosecution's case under section 304B IPC as against appellant must fail. Similarly, here in the case where learned trial court considering only the diary as a dying declaration cannot be considered as a sole evidence to convict petitioner for dowry death. Thus, it is humbly submitted that the learned court, taking into consideration only dying declaration and delivering the judgment without any corroboration, is erroneous in nature. Moving forward with the second limb of my argument is that the plea of alibi was not considered in our present case. It is humbly submitted before the Supreme Court that the judgment delivered by the learned court was on the sole basis of the diary written by the deceased, considering it as a dying declaration, not considering the plea of alibi submitted by the petitioner. The essence of plea of alibi was observed in the case of Dudnath Pandey vs. State of UP, cited as 1981, Volume 2, SEC, page number 166. It was held by the Supreme Court that the plea of alibi comes under the physical impossibility of the accused. That accused was present at the place of crime by reason to believe that his presence at another place. The plea of alibi can only be entitled that it is clearly shown that the accused was a present so for the place of the crime at the relevant time and he was not present at the place where the offense was committed. The petitioner took the stand of a plea of alibi stating that the petitioner was not at the scene at the time of the commission of the crime. It was humbly submitted that the appellants were not given a fair trial. It is established Supreme Court practice to allow a third review of the evidence in cases where there has been a illegality, procedural irregularity, or the violation of the principles of natural justice that has led to the absence of fair trial or a serious miscarriage of justice. Therefore, the third examination of the evidence is required in the instance case, since the Honorable High Court's decision was not just fair, or in accordance with the law. In the present case, the trial court didn't get into the plea of alibi. The defense of alibi is a legitimate defense, and in fact is often the only defense to show that a particular person is an innocent man, that as in our present case, and has not committed any crime. In the judgment of preceding courts, the substantial question of law is involved and grave injustice has been done by not getting into the plea of alibi. A judgment of the Honorable Supreme Court in one of the recent judgment is Ram Shankar and others versus State, cited as SEC 2022 MP 868, stated that the case of circumstantial evidence is primarily depend upon the prosecution story being established by cogent, reliable, and admissible evidence. Each circumstance must be proved like any other fact, which will, upon the composite reading, completely demonstrate how and by whom the offense has been committed. In the case of Dalam Veera Satyandam, which I have stated earlier, we are of the opinion that dying declaration can be accepted as being true, then all other evidence led by the prosecution would not help the prosecution to establish the case under section 304B, because the fact that even a married woman harassed by the demand for dowry may meet with an accident and suffer the death which is unrelated to such harassment. Similarly, in the present case, only the dying declaration brought by the respondent should not be considered to establish section 304B of IPC because of the fact that the petitioner was not at the time of the crime, and it is possible that the victim would have suffered from any other problem which led to the result of the death of Kiran Kumari. I would like to cite one more case. One second. I would like to cite one more case of Prakash Singh and others versus Union of India, 2006, Volume 8, SEC, page number 1. The prosecution has to prove the guilt of the accused beyond reasonable doubts. In the present case, there are a series of doubts, and the prosecution has not cogently and coherently established the guilt of the accused beyond reasonable doubts. Therefore, the accused conviction ought not to be upheld and is liable to be questioned. One of the basic principles of criminal justice system is that the benefit of doubt must always be extended in favor of accused. 1,000 culprits can escape, but one innocent man cannot be punished. Hence, it is humbly submitted before this honorable court that the allegation made in the trial court was unfair, and the respondent was unable to prove their allegation beyond the reasonable doubt with solid pieces of evidence which fulfilled the essentials of the law to convict the accused, and considering which there was a violation of the principle of natural justice. The plea of alibi is a legitimate defense and was not considered by the learned trial court and honorable high court, which brings to a conclusion that the judgment by the trial court and high court was erroneous in nature. If the judges are fully satisfied with the present issue, the council wants to move forward with the issue 4.
You may proceed.
Much obliged, Your Lordship. It is humbly submitted before this honorable court that Section 304B and 498A of IPC should be considered unconstitutional as it stands violative of Article 14, 23A and 21. First, I will clear that that Section 304B and Section 498A of IPC is the violation of Article 14, that is the equality before law. Article 14 of India's Constitution states that the state shall not deny to any person equality before law or equal protection of law within the territory of India. Means equality before law basically means that all persons should be treated equally, no matter whether they are rich or poor, male or female, upper caste or lower caste. This state cannot provide any special privileges to anyone in the country. It is also known as legal equality. As per Section 304B and 498A of the Indian Penal Code, they were established with the motive.
Counsel, I'm interrupting you here. What do you
Indeed.
have to say about Article 15, Clause 3?
I have not mentioned 15 clause 3, Your Lordship.
Yeah, you're talking about equality and you're saying that no class can be given special privileges, etc., etc. Hence,
Yeah.
I'm asking your opinion on 15.3.
The council wants to engage researcher for the same and want to answer the question at the end of the submission.
All right.
As per the Section 304B and 498A of Indian Penal Code, they were established with a motive to safeguard the women against the crime related to dowry demand made to them and their family, to women who were harassed for the purpose of dowry. But through the time, there have been many judgments which have been given by the legal authorities mentioning the section as to be misused. The charge of misuse is made particularly against Section 498A of IPC and against the offence of dowry death in Section 304B. But with this, the major motive of the section, that is to provide the safeguards to women, is being quashed and replaced as a weapon. Now it has become legally recognized alibi in hands of women in cases of which she decides to leave the husband's house and in-laws on prosperous ground and would still possess the entitlement of receiving alimony, rendering the husband and his family wretched. It is humbly submitted before this honorable court that the provisions mentioned under these acts are solely for the protection of women, and also the judgment delivered are mostly taking into consideration of the women. The judgment delivered the biased nature. There are some laws in the Indian Penal Code like Section 498A and other sections under chapter of cruelty and domestic violence, and it is also the Domestic Violence Act 2005 have number of provisions to intimidate men and their families. The effect of these laws is unjustified power in the hands of women for blackmail and extortion in domestic disputes, which irreparably damages the life of the husband and their relatives and sometimes also becomes the reason for their death. According to Melimuth Committee report, it was laid down that once the complaint or FIR is lodged under Section 498A of IPC, it becomes easy tool in the hands of the police to arrest or threaten the husband and other relative named in the FIR, even without considering the intrinsic worth of allegation and making a preliminary investigation. Similarly, in the present case, the petitioner also suffered the grief of losing the life partner, but was never fairly given a chance to be heard and defend himself for the allegation. The learned court, without considering the plea of alibi, convicted the petitioner solely depending on the dying declaration. The petitioner was deprived of his fundamental right of equality before the law. It is humbly submitted before the Honorable Court that constitutional validity of this section is violative of the principle of equality among the gender, as at one side it has been the area of incessant debate and both genders should be vested with equal rights and privileges. Second, moving forward with the second limb of my argument is that the section 498A is violative of Article 21, that is right to life. According to Article 21 of India's Constitution, which states that protection of life and personal liberty, states that no person shall be deprived of his life and personal liberty except according to the procedure established by law. Article 21 guarantees the right to life and personal liberty to each and every person, which cannot be violated even by the state, except when stipulated by the law to prevent encroachment on and the loss of life. Due section 498A is a non-bailable offence, and because of the false filing of the cases against the husbands and in-laws, the innocent people also suffer their integrity and liberty, which violates their fundamental rights under Article 21 of the Constitution. The apex court, in the case of Arnesh Kumar versus State of Bihar, cited as 2014 Volume 8 SCC 273, observed that a complaint under Section 498A allows immediate arrest and jailing of the accused since the offence is cognizable and non-bailable. Same in the case of Sushil Kumar versus Union of India, cited as 2005 Volume 6 SCC page number 281. This is the evidence of violation of human rights, and if the complaint is false and motivated, the Supreme Court also observed that complaints under Section 498A were being filed with the oblique motive to wreak personal vedanta. Family reputation is being defamed in the society due to false implication, which can lead to difficulty in unmarried children of the husband's family. In many families, husband or his parents commit suicide due to fear of false allegation put upon them. There are some reported circumstances in which the family of the husband has been adversely affected. Along with the circumstances, there are many situations in which the husband and his family are tortured and dominated in lieu of these provisions, which can adversely affect the mental health of the husband and the in-laws. As per above mentioned false allegations against innocents leads to mental agony, which leaves lifetime scars on the reputation of the family and the people involved in it. The Supreme Court therefore held clearly that there was the misuse and exploitation of provisions to such extent that it was hitting the foundation of the marriage itself and proved not to be good so for the health of the society in large. Court further believes that the authorities and the lawmakers had to review the situation and legal provisions to prevent such taking place. Justice in Melimit Committee on Reforms of Criminal Justice System, Government of India, Ministry of Home Affairs 2003, observed the following and gave the recommendation to amend the law immediately. The court may be suitably amended to make the offence under 498A of IPC bailable and compoundable. These are only a few observations of their lordships from scores that conclusively prove that a woman, not necessarily every woman, can be much crueler than a man, not necessarily every man. By intending to protect the life of a person, Section 498A of IPC jeopardizes around a dozen of innocent persons. Hence, the provision is discriminatory and in violation to Article 14 of the Constitution. Instead of restoring the equilibrium, the provision aggravates the disequilibrium. Hence, this is a failure of guarantee of right to life under Article 21 of the Constitution of India. For the reasons stated is not only imbalanced but also the ultra vires, that is beyond the powers. The fact that Section 498A is a cognizable and non-bailable offence has lent it in a dubious place of pride amongst the provisions that are used as weapons rather than shields by dislinked wives. The simplest way to harass is to get the husband and his relative arrested under this provision. In a quite number of cases, bedridden grandfathers and grandmothers of husbands, their sisters living abroad for decades are arrested. Along with the protection to the women, it should also be extended to the male members as according to the data, many husbands and their family who are innocent have been affected. And in generality, the voice of the victimized man is neither valued in the society nor law. So, since this section sometimes tends to be biased, and because of that, along with them, whole family suffers, therefore, it can be rightly concluded that this section, from its very motive, was inserted with the objective of safeguarding women from cruelty by his husband or in law or relative, but now is being misused. Therefore, measures are required to be taken to curtail further growth of misuse of this provision. Hence, it is humbly submitted before the Honorable Court that Section 304A and 498B of is ultra vires in nature and is violative of Article 14 and 21 of the India's Constitution, and they should be held unconstitutional.
उसको कॉपी करके ना गूगल में लिंक को पेस्ट कर देने पे आ जाएगा।
नहीं, ये बनाया गया है कंप्यूटर से ला ले।
मेरा नाम तो नहीं दिखा रहा वहाँ पे अनुप्रिया। जल्दी दिखाओ।
I think someone's mic is on.
फोन आ रहा है।
Guest user, please you mute yourself.
Okay, Council, you've been talking about the misuse of Section 498A. Is there any Law Commission report dealing with this issue?
Indeed, Your Lordship, there is a law. In fact, there are many case laws that can I cite?
No, my question to you is very specific. Is there any Law Commission report on the misuse of Section 498A?
There's only a Melamed committee till now, and committee
sure?
and there is one more is Committee on Reforms of Criminal Justice System by Dr. Justice V.S. Melamed. That is the Melamed committee only. The Committee on Reforms of Criminal Justice System.
Please go through Law Commission report number 243.
Okay. Indeed, Your Lordship. Indeed.
Okay, Council, my question is that you have mentioned severally that it is misused in various cases. It is true that it is misused, but in your case, there is a case of there is a death, and death. There are forensic team found that there are ligature mark around the neck. Okay. इसी मौसिक were present. Trachea was congested, bloody fourth was there, means it does not case of suicide. Whatever forensic team has found that, whatever, if you go through the post-mortem report, forensic team report, it is the case of murder, not the suicide. What's your opinion?
Indeed, Your Lordship, I would like to draw your attention to the postmortem report. That first of all, the body was highly decomposed, and according to the head of Department of Forensic Forensic Medicine, they found a ligature mark around the neck and dissection of the ligature mark. He found that echomosis were present and trachea was congested and was containing bloody food. So all the conditions are fulfilled when the person is committing the voluntary act. If the person is committing suicide, all the medical evidences which are present in my case are automatically present if the person commits suicide by hanging. So in my case, the accused is not present because he was at the office, and the plea of alibi is not considered in my present case.
Okay, contusions
am I
are
able
also
to?
there on the body marks. Just like contusions over the chin, over the
Indeed,
hand.
Your
It's
Lordship,
not possible in case of suicide.
Your Lordship, if I'll be permitted to answer this question on behalf of my co-counsel.
Okay, permitted.
Yes. To answer this question, Your Lordship, there are various reports that I have not cited, of course, but there are various reports that we read about the suicide, what happens to the body when a person commits suicide. So even though a person is mentally depressed, if the person wants to end their life, and as soon as they hang, the body resists. The body tries to let loose of the rope, and that is how we are contentioning that there must have been the contention marks around the hands and the fingerprints of the victim. Because when a person is getting hanged, even though no matter how depressed they are, the body will try to let loose of the same. And it is always safe to assume that the contentions over the hands contention is nothing but blue and black marks that happen because of lack of oxygen and blood clots. So it is very, we can also always presume that it could happen because she was trying to let the rope loose across her neck, Your Lordship.
Okay. Death is due to strangulation. Along with there is circumstantial evidence. It cannot be the sole evidence. Diary of the deceased. It cannot be sole evidence. It can be used in such. Dying declaration is an exception. Dying declaration is itself is an exception. Okay.
Yes.
Then what about that mentioned that dowry demand? Dowry demand is there. Severally, she had mentioned that dowry demands has been demanded. Dowry has been demanded by husband on. It may be she was maintaining diary. It means that it is presumed that she has mentioned on that particular day.
Your Lordship, if I am permitted to answer this question, and my co-counsel will continue after I answer this question. Your Lordship, talking about the dowry, it is very valid to understand the circumstance that considering the father of the victim, who is a renowned politician of the country of India, it is safe to assume that he is a well-educated man. And even if he is not, he has people to make him understand the laws and regulations of the country. Just because a person is not aware of the laws and regulation does not give him a right to cause wrong to the society. So if Chotilal, that is our client, had asked for money, why would he not report to the police in the first go? Why was there a to and fro and a never-ending cycle of the entire scenario? How is it safe to assume that just because there are allegations against my client, against our client, that he asked for the dowry, why is there no sudden contentions against the fact that the father also gave away 10 lakhs of rupees? Because when it comes to dowry, the person who paid the dowry is also as much responsible as the person who asked for it.
It's okay.
Continuing to the facts, I would like to draw the attention of honorable lordships to the circumstantial evidence that you have mentioned. Here, there is a break of circumstantial evidence. First of all, the marriage was solemnized. Then, on 5th August 2020, Kiran Kumari went to a parent's house. But Chotelal Kumar had a change of heart and he brought the wife back to his home and also apologized and promised to make her happy. And if we have the mens rea to committing the act, then why should they have the change of heart and went wife to the home? And there is a break of circumstantial evidence here because for the 2 years everything is fine. And after the 10th September, Chotelal Kumar is asking for the only rupees 60 lakh, and that too it is written clearly in the fact sheet that they are asking for 60 lakh rupees for the purchasing of the plot. So it is also established in case of Rohtash versus State of Haryana. Rohtash versus State of Haryana, cited as AIR 2012 SC 2297. In that case, it was held that demand of dowry for establishing business, showing the appeal against the judgment of the High Court of Punjab and Haryana, and is not necessarily demand of dowry. There's a Supreme Court judgment. And while the High Court had reversed the judgment and the order of the Sessions Court, by which appellant had been acquitted of the charges of Section 304B and 498A of IPC for committing suicide by the deceased aged about 21 years. Similarly, in the present case, the appellant was demanding the dowry from the father of the deceased so that they can establish a good business. And he have changed the mind. So there is a break of circumstantial evidence. And secondly, for answering of your question of dying declaration, I want to cite one case law, that is Munnu Raja versus State of MP, cited as 1976 volume 3 SCC 104 page number. The Supreme Court stated that a law pertaining to the admissibility of the dying declaration should be applied and understood with a caution, because the declarant making such statement shall not be cross-examined by the accused. And there is one more foreign case is Nava versus Rusik, where the Honorable Court held that the statement of the deceased person is irrelevant unless the cost of the death of the person making such statements comes into the question. So in the present petition also, the deceased wife made the statement only about the dowry, and not about the reason behind the cause of her death. Hence, the personal diary cannot be considered as a part of dying declaration.
Okay.
Well, Council, I have a submission here. You've been talking about the misuse of Section 498 capital A, but you could not really defend. How is it not cruelty in your case?
Ma'am, your lordship, there is not no cruelty in our present case established, because according to the facts mentioned, there is no cruelty by the husband.
And what about the dowry demands? I mean, of course, you were trying to justify it right now, but altogether, I feel that you have, you've not targeted the point that how 498A is not applicable to you. How is it not made out? You focused more on the criticism of 498 capital A.
For this, I want to state that yes, in the case of Shanti versus State of Haryana, cited as AIR 1991 SC 1226, to explain the ingredients of Section 304B. A careful analysis 304B shows that the following essential. First is the death of a woman should be caused by burns or bodily injury or otherwise under the normal circumstances. So the first essential is not fulfilled in the present case. Secondly, the death should be the 7 years of marriage. And thirdly, she must have been subjected to cruelty or harassment by her husband or any relative of the husband soon before her death. So there was no cruelty soon before her death.
Okay, counsel. Even if a person is acquitted under 304B, can he be convicted under 498A? Is my question understandable?
Indeed, your lordship, Section 498A and Section 304B are the like different offences altogether, because 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 Section 304B is a dowry death that is punishable, and such that should have been occurred within 7 years of marriage, and
Right.
this period of limitation is not there in Section 498A of IPC.
Absolutely.
And it was also cited in the case of Soni Devraj Bhai Babu Bhai versus State of Gujarat, cited as 1991 Criminal Law Journal, page number 313 of the Supreme Court. It was held that Section 304B is substantive provision creating a new offence and not merely a provision effecting a change in procedure for trial of a pre-existing substantive offence. And as a consequence, accused cannot be tried and punished for the offence of dowry death provided in Section 304B with the minimum sentence of 7 years imprisonment for an act done by them prior to the creation of the new offence of dowry death. And I also want to mention one more case of Shanti versus State of Haryana, AIR 1991 SC 1226, in which in-laws insisted for the dowry from the daughter-in-law. Ultimately, it appeared that she was done to death and her body was cremated
Counsel,
without.
I've asked just a one-liner. Just answer me in a yes or a no. That's it. Shall I repeat my question?
Indeed, your lordship.
If a person is acquitted under Section 304 capital B, can he be still convicted under 498 capital A? That's it. Just a
Indeed, your
yes or
lordship.
a no is needed.
Indeed, your lordship.
It's possible?
Indeed.
Okay. Thank you.
Uh, any more questions from our honorable lordships?
That's it from my side. Yes, sir. Anything at your end?
So, with the due permission of your lordships, the council wants to proceed with the prayer.
Okay, proceed.
Please.
In the light of the above facts stated, issues raised, arguments advanced, and authorities cited. The respondent humbly prays before the Honorable Court to be graciously pleased to declare that the SLP filed by the petitioner was maintainable as a substantial question of law was involved. Secondly, the diary shall not be considered as a piece of sole evidence for dying declaration. Thirdly, the orders given by the trial court and Honorable High Court was erroneous in nature. Fourthly, to declare that section 304B and 498A to be unconstitutional and may pass any other order that it may deem fit in the ends of justice, equity and good conscience. For this act of kindness, the respondent, the petitioner in the present case shall forever pray, all of which is humbly submitted.
Respondent side.
Is the counsel audible?
Yes, you are.
Audible.
Much obliged. The counsel solicits permission from the bench to plead.
Granted.
Much obliged. The counsel recognizes the gracious presence of your ladyship. However, for the convenience of the proceedings, the counsel seeks permission to address the bench as your lordship.
Sure.
Much obliged, your lordship. Could your lord warm greetings? May it please this honorable court. This is counsel appearing on behalf of the respondent in the action. This is Speaker 1. The counsel appearing on behalf of the respondent in the instant case Chotilal Kumar versus the state, along with my learned co-counsel Speaker 2. Would your lordship appreciate a brief summary of the facts in hand?
I don't think it's required, sir.
Much obliged to your lordship. In the instant case, your lordship, this respondent will be handling 4 distinct issues of law to substantiate our case. The counsel will be dealing with the first and the fourth issue, and my co-counsel will be dealing with the second and third issue. Much obliged, your lordship. The first issue that I'll be addressing today is whether the special leave petition filed by Mr. Chotilal Kumar is maintainable. It is humbly submitted before this honorable court that the current special leave petition is not maintainable because special leave petition cannot be granted when substantial justice has been done and there is no exceptional circumstances that would allow this case to be maintained. The appellant has to prove that this is the special circumstance. Going in details, firstly, the special leave petition should be dismissed as this is not an exceptional case. In Preetham Singh versus the state, AIR 1950 SC 169, the Supreme Court held that the Article 136 is to be exercised sparingly and in exceptional cases only. And as far as possible, a more or less uniform should be adopted in granting special leave in the wide range of matters which can come up before it under this article. The court further stated that the only uniform standard which in our opinion can be laid down in this circumstance is that the court should grant special leave to appeal only in those cases where again special circumstances are shown to exist. This was again reiterated in Hemraj versus State of Ajmer, which stated that even when the appeal is admitted, the appellant has to prove that the special circumstances exist and there has been grave injustice. Only then the overriding powers under Article 136 would be exercised by the court. In another case, Council of Scientific and Industrial Research versus KGS Bhatt and State of Himachal Pradesh versus Kailash Chand Mahajan, the court observed that the special leave will not be granted when there is no failure of justice or when substantial justice is done, though the decision might suffer from some legal errors. The respondent respectfully contends that in order to justify a review of the decision under appeal on the basis of the case merits, the petitioner must establish that exceptional circumstances exist and that failing to intervene would cause a serious injustice. Therefore, the court will dismiss the special leave petition if it comes to the notice that the case is not exceptional. The present case is similar to any other case. There are no existence of any exceptional or special circumstances and no substantial question of law that will make the Supreme Court to grant the appeal in this present case.
Similar views were upheld in the cases of Mathai and Joby versus George and another, and N. Suryakala versus Mohan Das and another's, Tirupati Balaji versus State of the Art. The court in these cases held that the apex court is not normal court of appeal. The Article 136 constitutes an extraordinary jurisdiction and vests vast discretionary power to interfere in exceptional cases only. The present case is similar to any other case. There are no existence of any exceptional or special circumstances and no substantial question of law that will make the Supreme Court to grant the appeal. Secondly, the scope of special leave petition, as mentioned in Jamsed Harmasji Wadia versus Board of Trustees. The court held that the power is permitted to be invoked, not in a routine fashion, but in very exceptional circumstances, as when a question of law of general public importance arises, or a decision sought to be impunged before the Supreme Court shocks the conscience. The Supreme Court would not, under Article 136, constitute itself into tribunal or court, just settling dispute and reduce itself to a mere court of error. In the present case, there is no question of general importance, general public importance. Neither the Supreme Court is shocked by the conscience of the case. Specifically, Supreme Court cannot reduce itself to the mere court of error, and this is itself established by the Supreme Court. The power under Article 136 is an extraordinary power to be exercised in rare and exceptional cases and on well-known principle. It has become a tendency of filing special leave petition against all types of orders given by the High Court without taking note of the scope of Article 136. This article was never meant for the Supreme Court to be an ordinary court of appeal. Under the constitutional scheme, ordinarily, the last court in the country in ordinary cases was meant to be the High Court. The Supreme Court, as the apex court in the country, was meant to deal with important issues like constitutional questions, questions of law of general public importance, or where grave injustice has been done. And this has been clearly held in Mathai alias Joby versus George and another. In the present case, there is neither any question of law nor any grave injustice has been done to the appellant. It is so an ordinary case, and thus the special leave petition is not maintainable. All the material evidences were taken into consideration, and the order were passed by the Honorable Court without any biasness or unfair application of law. The judgment of the High Court stands valid, and therefore the petition must be dismissed. Entire Khatun by LRS versus Salam bin Mohammed, the Supreme Court held, we are not bound to go into merits, and even if we do so and declare the law or point out the error, still we may not interfere if the justice of the case on facts does not require interference, or if we feel that the relief could be molded in a different fashion. It is humbly submitted before the Honorable Court that there is no requirement to entertain the matter because there is no reason of intervention required in the present case. However, if the court wishes to accept the petition, then it is required not to hear the matter on its merit. Thirdly, grounds of special leave petition which is granted are not satisfied. There are some grounds on the basis of which the special leave petition is not granted. When the tribunal fails to exercise its patent jurisdiction, when there is apparent error on the face of the decision, when the tribunal has erroneously applied well-accepted principles of jurisprudence, and when the tribunal acts against the principle of natural justice or has approached the question in manner likely to cause injustice. In the present case, Your Lordship, the learned trial court and the High Court were within the jurisdiction to try this case and give the verdict for the same. There is no erroneous judgment passed by them, as they have taken note of the whole situation that occurred and examined the material evidences. The court have exercised their power keeping in mind the principle of natural justice and have ensured that no grave injustice has been done. Hence, it is humbly submitted before this Honorable Court that no valid grounds can be made to accept the special leave petition. Lastly, according to the doctrine of exhaustion of alternative remedies, all statutory solutions must be exhausted before approaching the Supreme Court under its special jurisdiction, unless special circumstances can obviously be demonstrated to persuade the court that the appeal must be allowed. The petitioner had the option of appealing to the High Court's higher bench or filing an application for revision. The respondent humbly submits that in light of the apex court precedents, the petitioner's failure to exhaust the alternative remedies available to them renders the current special leave petition unsustainable. Your Lordship, As I'll be arguing the next submission, the Council seeks permission to begin with its arguments. Much obliged, Your Lordship. The next issue that the Council will be dealing with is whether Section 304B and Section 498A of the Indian Penal Code 1860 is unconstitutional. The state would humbly submit before the Honorable Court that Section 304B and Section 498A of IPC are in fact constitutional, as it is clearly seen that the increase in number of dowry deaths and cruelty is a matter of serious concern. Firstly, abuse of legislation that has been contended by the petitioners does not in itself invalidate anything as unconstitutional. In the case of Sushil Kumar Sharma versus Union of India, it was provided that it is well settled that mere possibility of abuse of provisions of law does not per se invalidate a legislation. Though there are numerous cases with false allegations of dowry death and cruelty under Section 304B and Section 498A of IPC, it cannot be declared unconstitutional. In another case of A. Thangal Kunju versus M. Venkatachalam Potti, official and income tax officer, it provided it is to be presumed, unless the contrary was shown, that the administration of a particular law would be done not with an evil eye and unequal band. In the case of Buddin Chaudhary and Oates versus State of Bihar, which is a very important case, Your Lordship, the court referred to the contention of another case, namely Snowden versus Hudgens, wherein the court held that the judicial decision must of necessity depends on the facts and circumstances of each particular case, and what may superficially appear to be an unequal application of the law may not necessarily amount to a denial of equal protection of law, unless there is shown to be in the present case an element of intentional and purposeful discrimination. Further, the discretion of the judicial officers is not arbitrary. It also held in the similar case that the court repelled the contention holding that on the possibility of abuse of a provision by the authority, the legislation may not be held arbitrary or discriminatory and violative of Article 14 of the Constitution. It must be understood that whenever legislation is passed, it is passed not with an evil intention. The validity to such legislation is given by the judiciary, and if it is unconstitutional, it declares the said law as ultra vires. The constitutional validity of Section 304B and 498A of IPC have been upheld in several judgments, namely Sushil Kumar Sharma versus Union of India and others, Balakrishna versus State of Maharashtra and others, P. Salais Narayan versus Polavaram Pullam Sundarya Valli. In the case of Krishna Lal and Oates versus Union of India, it was contended by the respondent that it was further highlighted that the evil of dowry has spread its tentacles by leaps and bounds, and even the spread of education has not helped to liberalize the attitudes of the society regarding dowry. On contrary, even in educated society in the urban areas, such incidents have increased considerably. In many cases, higher the education of the boy, greater the demand of dowry. Under these circumstances, the legislature thought it fit to enact special provision of Section 498A and 304B of the Indian Penal Code for curbing the vice of cruelty towards married women as well as dowry debt. Secondly, Your Lordship, Section 304B and 498A of IPC are not violative of fundamental rights. Article 14 is the fundamental right guaranteed to all the citizens of India. It provides equality before law. This provides that all persons are equal before the law and are entitled to receive equal protection before the law within the territory of India. In the case of Inder Raj versus Sunita, Section 498A of IPC was challenged on the grounds that it was violative of Article 14 of the Indian Constitution. However, it was held that wide erections have been given to the court in the matter of interpretations of the word occurring in the laws, and also in the matter of awarding punishment. If giving this discretion to the court is thought to be conferring arbitrary powers on the court, most of the provisions of law will have to be struck down as ultra vires. It is well-established principle of law that such discretion cannot be said to be arbitrary and thus does not come into conflict with Article 14 of the Constitution. Article 15(3) of the Constitution clearly clearly states that the state can make any special provision for women and children. This is created to protect the women from cruelty that they have been facing for a long period of time, which is further driving them to commit suicide or are becoming an easy target of murder and violence pelted on by husband and husband's family. Therefore, Section 304B and 498A of IPC stands to be constitutional, valid, and inter vires. Lastly, even though Section 498A and 304B are not gender neutral, it cannot be contended that they are gender discriminatory. Merely because there is an abuse of the provision does not mean it can be declared invalid. The evil of dowry has spread again its tentacles by leaps and bounds, and there is a need for gender specific law to protect women for such evil. Even though these sections are not gender neutral, they will continue to hold its validity and remain constitutional. This is further protected under Article 15.3 as discussed previously. The Council now seeks permission to call upon its co-counsel for further submission if your lordship is satisfied by the arguments present.
You may proceed.
Warm greetings to your lordship. I, co-counsel Speaker 2, will be arguing on the remaining issues. Your lordship, as I will be arguing the remaining submissions, the co-counsel seeks permission to begin with its arguments. Much obliged, your lordship. The issue that the council will be addressing today is whether the diary written by Kiran Kumari can be considered as a piece of dying declaration. It is humbly submitted before this honorable court that the diary recovered by the police during the investigation must be considered as a dying declaration. Dying declaration has been defined under Section 32 of the Indian Evidence Act. And even though this section does not exclusively highlight the term dying declaration, but the implied intention points towards it. An important ingredient for an evidence to be a dying declaration is that it must relate to the cause of death or the circumstances of the transaction which resulted in that person's death. As these were held in the cases like Didi Gram Bhikshapati and another versus state of Andhra Pradesh, Tapindar Singh versus state of Punjab, Ukaram versus the state of Rajasthan. The expression circumstances of the transaction which resulted in his death means that there must be some nexus between the circumstances and the death of the victim. The instant case, your lordship, satisfies this ingredient as the diary has established sufficient nexus because it narrated the ways husband used to make demands. Demanding dowry is in itself an illegal demand, which has led to the downfall of their marriage and subject the victim to cruelty. As per the case of Sharad Birdi Chand Sarda versus the state of Maharashtra, your lordship, the justice had held that when main evidences consist of statements or letters written by the deceased which are in direct connection or related to the death of the deceased and which reveal a telltale story, then they are admissible and distance from of time alone in such case would not make the statements irrelevant. Your lordship, I would also like to state that according to section 32, it is not necessary that the person has to be on the deathbed, because under section 32, it is clearly stated that such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death. Secondly, your lordship.
Counsel, I completely agree with you on that note, but I have a question here.
Yes, your lordship.
That at the time when the diary was written, she was no more anticipating her death. Okay.
Yes, your lordship.
Your daily diary is a mere expression of your feelings that you're undergoing at a given point of time. So, how do you justify this argument?
Your lordship, the diary was written for since a long period of time, like right before her matrimonial life, and the day the dowry was being demanded, she wrote each and every event that had occurred. She wrote how the husband used to make dowry demands. So that is sufficient to establish that demanding dowry, as I said, is in itself an illegal activity. And if someone is demanding dowry, it is mentioned in the facts that the marriage was in doldrums. So we can.
Correct. Maybe we can take it as a piece of evidence for Section 498A, but can we take it as a dying declaration in this scenario?
Your Lordship, we can take it as a
That is
dying
what I'm
declaration.
trying to ask you. That I agree that expectancy or fear of death is not necessary. But then, what about the fact that you're not even anticipating your death when you're expressing your feelings in a diary?
Your Lordship, for making an evidence like diary as a dying declaration, there is one essential that the ultimate outcome must be death. That is why there is a dying declaration. And in the present case, there was the death of the victim. So it must be considered as a dying declaration. Apart from that, for making a diary as a dying declaration, as said that the person should not be confused. So when the diary was being written, the person was not confused, but it all narrated the ways the husband used to demand dowry, which in turn and these demands, which in turn coerced the victim to commit suicide. And therefore, the diary must be considered as a dying declaration.
Okay, you can proceed.
Thank you, Lordship. So, as previously argued, the cause of victim's death is in fact a question, and the circumstances which led to her death have been established by the diary. As per the case of Sudhakar versus State of Maharashtra, Your Lordship, the court held that as distinguished from the English law, for a statement to be relevant under Section 32 of the Indian Evidence Act, it is not required to be made an expectation of death, and that statement of victim who is dead is admissible insofar as it relates to the cause of the death. The language of Section 32, Clause 1 of the Indian Evidence Act gave rise to the proposition that in the case of Sharad Birdhichand Sarda versus the state of Maharashtra, it was held that distance of time would depend or vary from circumstances of each case, where the death is a logical culmination of a continuous drama, long in process, and is a finale of the story. The statement regarding each step directly connected with the end of the drama would be admissible because the entire statement would have to be read as an organic whole and not torn from the context. Your Lordship, in the present case, the marriage between the victim and the accused was in doldrums, and she also narrated the ways dowry demands were made through the diary. In addition to this, Your Lordship, the father of the victim knew of such dowry demands because he paid the huge sum of money to his son in law. Due to such continuous cruelty related to dowry demands, the victim was led to take such an extreme step. Therefore, the diary must be declared as a dying declaration and admissible before the court of law. Your Lordship, another important ingredient for a statement to be a dying declaration is that it should be truthful and credible. In the case of Lalubhai Devchand Shah and others versus State of Gujarat, the Supreme Court had held that a dying declaration must be scrutinized to the extent of its truthfulness, like any other material pieces of evidence. Your Lordship, the diary in the instant case is coherent, consistent, true, and voluntary, therefore satisfying the above ingredient. It must be considered as a dying declaration. The diary is credible because it showed the ways demands were made for the dowry. The truthfulness of the diary is established by the fact that an FIR was filed by the father on the pretext of dowry. The medical injuries and the mental trauma that the victim suffered are sufficient evidences to show that the statements which are mentioned in the diary are truthful. And the victim was not in any state of confusion because the diary was being written from the very beginning of the matrimonial life. She has written the contents in a diary which are truthful and in a fit mental state. In the case of Sharda versus State of Rajasthan, Your Lordship, the court here observed that if the dying declaration is to be completely excluded in a given case, it may even amount to miscarriage of justice, as the victim alone being the eyewitness is a serious crime. The exclusion of the statement would leave the court without a scrap of evidence. Thus, in the present case, Your Lordship, the diary must be considered as a dying declaration. If not, it will lead to serious miscarriage of justice. Your Lordship, even though the diary did not prove in great detail the reason behind her death for the sake of the argument, the court is not justified in ignoring the smallest of the information provided there. Even though the diary did not give sufficient happenings of the events, it cannot be rejected as a dying declaration on merely this ground. In the case of Paniben versus State of Gujarat, the court reached the following conclusions after reviewing the entire scope of law on the principles of governing dying declaration. Your Lordship, in the case of State of Maharashtra versus Krishnamurti Lakshmipati Naidu, wherein the Supreme Court held that the learned judges of the High Court were not justified in ignoring the dying declaration of the deceased merely on the ground that it did not include any statement as to how the accused had received the injuries. Further, in the case of Kusa and another versus the state of Odisha, Your Lordship, the court held that even an incomplete dying declaration can be held reliable, even if the deceased, having narrated the full story, fails to answer the last formal question as to what more he wanted to say. Therefore, in the instant case as well, even though the diary did not give complete details of the events, it is not justified to be rejected as a dying declaration. Furthermore, Your Lordship, the learned trial court and the High Court, which are of such great intellect, have considered the diary as a dying declaration. A court can err once, but they cannot err twice, considering that they are of such high intellectual people. They are such high intellectual judges. They have deeply scrutinized and examined all the material evidences, and on that basis only they have declared the diary to be a dying declaration. On satisfaction of the above grounds, it is respectfully submitted before this honorable court to consider the diary as a dying declaration. The council seeks permission to move on to its next submission. Much obliged, Your Lordship. The next issue that the council will be addressing is whether the judgment of the learned trial court and the honorable high court is erroneous. It is submitted before the honorable court that the judgment of the learned trial court and the high court is not erroneous. The courts are successful in establishing the guilt of the accused for causing cruelty and death of the victim by fulfilling necessary essentials. Your Lordship, in the case of Kamesh Panjiar versus State of Bihar, Kashmir Kaur versus the State of Punjab, the essentials for Section 304B of the IPC were established as that the death of a woman should be caused by burns or bodily injury. Death must have occurred within 7 years of marriage, subject to the cruelty by husband or the relatives of the husband, and cruelty must be connected with the demand for dowry. Your Lordship, focusing on the very first essential that the death of the woman should be caused by burns or such bodily injury. Your Lordship, from the facts, it is mentioned that on examination by the head of the Department of Forensic Medicine, the doctor found several contusions in various parts of the body, such as the hands, axilla, etc., and reported that the victim had died because of strangulation. The first essential that the woman must be subjected to bodily injury stands fulfilled. Your Lordship, it must also be noted that medical evidence is admissible before the court of law as per Section 45 of the Indian Evidence Act, which was also held in the case of Solanki Chimmanbhai Ukkabhai versus State of Gujarat and Shudhakar versus State of Madhya Pradesh. Your Lordship, in the present case, the admissibility of the medical opinion by the doctor must be accepted and admitted along with the diary which is narrated the ways demands were made and which is being treated as a dying declaration by the learned trial court and honorable high court. Focusing on the second essential, Your Lordship, death must have occurred within 7 years of marriage. The facts of the case clearly presents that within 2 years of the marriage of the victim, she was subject to cruelty because of dowry demand, which led to her death. The facts provide that they got married on 1st January 2020 and on 15th October 2022, the victim was found hanging. Your Lordship, here the term soon before was pointed out as an important ingredient of Section 304B as held in the case of Rajendra Singh versus State of Punjab. Your Lordship, this term soon before is a very relative term and may differ from case to case. This was held in the case of Surinder Singh versus State of Haryana. It is not synonymous of the term immediately before, which was held again in the case of Kans Raj versus the State of Punjab. Your Lordship, in the present case, there is a close interval between the cruelty and the death of the victim. The cruelty has been shown through the diary and the cruelty for the dowry is shown to persist, and thus this essential also stands fulfilled. Moving on to our third essential is that the woman must be subject to cruelty by husband. Is that the woman must have been subject to cruelty by husband or the relatives of the husband. Your Lordship, this essential stands fulfilled along with section 498A because the term cruelty means the same in both these sections, and this was held in the case of Kalya Perumal versus the state of Tamil Nadu. The accused has fulfilled the requirements of section 498A as there was a willful conduct in treating the deceased cruelly and coercing her to meet unlawful demand for dowry. Your Lordship, apart from the fact that she suffered bodily injury, the victim was also exposed to mental trauma, which falls under the ambit of cruelty. And this was held in the case of Baijnath Madhesia versus State of Bihar and Samar Ghosh versus Jaya Ghosh. It can be highlighted based on the fact that their marriage was in doldrums. The accused apologized to the victim and promised to keep her happy, and that the accused continued to demand dowry. Moving on to our fourth essential is that cruelty must be connected with the demand for dowry. The cruelty faced by the victim leading her to commit suicide shares sufficient nexus with the demand for dowry. Your Lordship, the husband demanded dowry, which made her life miserable and made her matrimonial life unstable. In the case of Sher Singh versus State of Haryana, it was held that the initial presumption of innocence is replaced by an assumption of guilt on the accused, thus transferring the heavy burden of proof upon him. Your Lordship, the Indian Evidence Act provides section 113B, where when the question is whether a person has committed the dowry death of a woman and subject her to cruelty, it is presumed that such person has caused her death. Your Lordship, this was also held in the case of Hemchand versus State of Haryana, and in this case, there were similar circumstances and the appeal was dismissed, therefore also satisfying our issue that the SLP or the special leave petition is not maintainable. Therefore, Your Lordship, in the instant case, the husband is in question of causing cruelty, and therefore, in accordance with law, he is presumed to be guilty of causing a death. It is humbly submitted that all the essentials of both these sections are fulfilled, and the learned trial court and honorable court, High Court, have not erred in their judgment. The council seeks permission to move on to its prayer.
Okay, before that, tell me one thing.
Yes, Lord.
Why haven't you made use of the Dowry Prohibition Act 1961?
Your Lordship, the Dowry Prohibition Act only mentions that demanding dowry is wrong. It does not mention about anything about dowry death of a victim or the cruelty leading it. It only mentions the demand for dowry.
Good. All right. I think you can move ahead with your prayer. Sir, do you have any questions? Devesh, sir?
No, ma'am.
Okay, I think then you can move ahead with your prayer.
Much obliged, Your Lordship. Whereof it is prayed, in light of the issues raised, arguments advanced, and authorities cited, that this Honorable Supreme Court may be pleased to adjudge and hold that the special leave petition is not maintainable. The diary written by Kiran Kumari can be considered as a piece of dying declaration. The learned trial court and Honorable High Court have not passed an erroneous judgment. The section 304B and 498A of the IPC 1860 are constitutional, and pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good governance. And for this act of kindness, the respondent shall, duty bound, humbly pray.
Can the prosecution proceed with the rebuttals? Can the prosecution proceed with the rebuttals? Your Lordships.
Yes, sure.
it is humbly submitted that all the factors mentioned by a learned opposition of the respondent side to prove their lack of knowledge with respect to asphyxia, the cause of bloody fourth and congested trachea, need not always be because of strangulation by a third party, but the same also happens when a person commits suicide by hanging, as taken from the articles of NCBI reports. Secondly, no evidence regarding fingerprints, no medical evidence to indicate that perpetrator is the accused. Your Lordships, again to mention the contusions on the hands of the victims, it is valid to note that a person committing suicide, no matter how depressed, the body will resist and will try to set loose and save themselves from the pain. Contusions are mostly black and blue marks around the fingers, which might as well as happen when the victim tried to set the rope loose around the neck when she was struggling to breathe. Our learned opposition's accusation is based solely on hearsay evidence and the dying declaration by the deceased, which has been taken as an evidence as the status of dying declaration. Our learned opposition mentioned how for a dying declaration to be admissible, the only element that need to be met is that the end result should be death of the victim. And if this was satisfied, any piece of manuscript could be termed as a dying declaration. The diary entry is just a written statement. There are two essentials for diary entry to be termed as a dying declaration. That is, the person must be on his or her deathbed. And secondly, there needs to be an apprehension of death. And none of those elements was satisfied in the present case. The victim was not on a deathbed when she wrote the diary, and she definitely wasn't apprehending her death. It is essential to understand that diary was just a mere general entry and it was not a declaration in any way, Your Lordship. It is humbly submitted that my learned opposition resides in a world of imaginations where their only intent is to tunnel vision in our client. The opposition was not able to give us the reason to believe that the facts stated had not been impaired at any time. She was making the statement by circumstances beyond her control. The learned opposition were not able to give us the reason to believe that the statements written in the diary has been consistent throughout if she had several opportunities of making a dying declaration apart from the official record of it. There is no even no official record of any such document, and the learned opposition was not able to give us the reason to believe that the statement had been made at the earliest opportunity and was not the result of tutoring by the interested parties. Your Lordship, in the adversarial system of law, which a country like India follows, a guilty man may be allowed to go unpunished, but an innocent man must not be wrongly punished.
May I go for the Sar rebuttal, if it's pleased by the lordships? Okay.
Yes.
The petitioner has mentioned that the contusions were not given by the accused. Sure, okay, fine. Even if we take in consideration that the petitioner or the accused Chotilal Kumar did not bring in the contusions, Section 304B of IPC clearly states that there has to be either burns or bodily injury or occur otherwise than under normal circumstances. The death here is not normal circumstances. It's not a natural death, it's an unnatural death. The suicide, even though not murder, will be considered as one of the essentials ingredients for 304B of the IPC. Clarifying that question, where it was placed that it is a case that murder has nothing to do with it, it's clearly stated in section 304B that it's supposed to be within 7 years of marriage. It is supposed to be cruelty on demands of dowry, and there has to be demands of dowry. The respondent has very clearly established there were demands of dowry, there were mental harassment. Section 498A of IPC clearly states that the cruelty could be in terms of mental or physical harassment. If even if you contend that cruelty in terms of physical harassment was not established beyond reasonable doubt, mental harassment to the victim was established beyond reasonable doubt. The fact that marriage is an institution very important in the society of Indiva, and the fact that she was sent back to her house stating that if she won't get 60 lakh rupees, she's not supposed to come back to her house, and demanding dowry again and again, causes a lot of mental harassment and mental stress to not only the victim but also the family of the victim. So here, cruelty, as in accordance with section 304B and in accordance with 498A of the IPC, has been established. The demands for dowry has been established and has been attested by corroborative evidence given by father, which is it was not an it was not an evidence given by some uncle or some neighbor. It is a father, which is an important thing to consider, that the father itself is saying the fact that the dowry demands were made. So all the necessary ingredients for the accused to be convicted under section 304B is fulfilled. Secondly, you talked about death must be imminent. It has clearly mentioned, the Supreme Court, in comparison to the English law, has widened the scope of soon before death and has mentioned that soon before death necessarily does not have to be just few hours before the victim takes her life. It could be tabulated in days or months depending upon circumstances of the case. So when you contend that death must be imminent and has been mentioned by the Supreme Court, yes, sure, it has been mentioned in a few cases by the Supreme Court, which was later again rectified by the Supreme Court in several cases, widening the scope of soon before death and dying declaration. That will be all from my end, Your Lordship.
I would like to add one point that our learned opposition failed to establish the ingredients first of section 304B, the other circumstances which he mentioned. The other circumstances is not proved by a learned opposition. And secondly, there is a break of chain of events. So there is a big iota of doubts, and the benefit of doubt must be given to the accused, because thousands of the thousands of accused can go, but the one innocent martyr cannot be convicted.
Could I go for the Sarah bottle, ma'am?
Yeah, okay, please.
Yes. Just in the first question itself, I already established how my learned co-counsel has already proven the entire four essentials of section 304B of the IPC. So I do not think that your question is valid. In fact, you yourself in your case mentioned the case of Hemchand versus state of Haryana, and you mentioned specifically that the cases were on the similar grounds. You agree to it. You agreed to it, right? But you mentioned that the appeal by the Supreme Court was granted, which was not true. In fact, the appeal by the Supreme Court was not granted. Also, you've mentioned that the diary cannot be considered as a dying declaration, and you mentioned that it is very necessary for a magistrate to actually take the dying declaration. Now, if the magistrate always have to record the dying declaration, no suicide notes, no diaries would ever be considered as a dying declaration. To mention the same, I would like to go into the case laws. Just a second. Yes.
I want to remind the our learned opposition that this is a mere rebuttal, and there is no scope for the case law in the rebuttal. And I want to
No, I'm sure my
restate.
answer can be. I'm sure my answers can be backed by a case law to just
and,
bring in.
and I want to repeat my point about the dying declaration, that the essential conditions are not fulfilled in the present case. The two essential conditions which I have stated is not fulfilled in the present case. So how the dying declaration, how the diary can be declared as a dying declaration? It
No,
cannot.
Lordships, again to mention, my learned opposition just rightly mentioned right now that suicide notes, they made a mere comparison between a suicide note and a dying declaration, which are completely different things when it comes to
No,
the law of evidence.
no, they're basically both considered as a document under section 4 of the Indian Evidence Act, and hence it can actually be compared and be considered as a dying declaration. I was bringing a mere comparison as considering them as a document.
Okay, I think we can close it here.
Your Lordship, again, I'd just like to mention a small brief information. That is, my learned opposition just mentioned that the marks on the hands that we found, it was an extraordinary event. But as per the reports made by the New England Journal of Medicine, it is rightly mentioned that when a person commits suicide, the contusions on the hand are not an extraordinary event. With this, we rest our case, Your Lordships.
The organizers, I request you to please intervene.
Sorry, we beg your pardon, Your Lordship.
Yeah, I was just requesting the organizers to
Organizer.
intervene. Yeah.
Yes, ma'am. Please give the feedback, important feedback to the participants.
Yes, certainly. So, would you like to give it first?
I beg your pardon.
Devesh, sir, would you like to give a feedback first? Devesh, sir, am I audible to you? I don't think that is the case at the moment. All right. See, personally, I feel this whole problem was more
Okay.
challenging for the
Firstly,
petitioners. Yeah, so please go ahead.
team code 41. Okay, ma'am. Firstly, team code 41. Both. Am I audible, ma'am?
Yeah, so now you are.
I think technical glitches. Okay. The problem was obviously challenging for both the teams, and both team have right point, or they have pointed very well from their side. Particularly, team code 41 had more challenges as per the facts of the cases. Even though they have presented very well, they have rebutted very well. And again, team code 52. Just you have to give a smile on your faces. Both were very serious while presenting their case. Will be beneficial for you in the future. Just, you have contested very well. You have presented your case very in a very well manner. And in rebutting, you also have very good point. You have contested very well. All the best. Okay, ma'am. From your side.
Okay, no, I would like to congratulate both the sides. I think both did exceptionally well. But as I was mentioning, as per the facts of this case, in my personal opinion, I think it was more challenging for the petitioner. So very well done, guys. You've done a really good job in whatever you have prepared. But yes, so for example, I had asked you how, what about Article 15, Clause 3, and you did not have an answer to that particular question at that point of time. So these fundamentals should be on your tips. Okay. So that's about it. But all in all, a very good job. As far as the respondents are concerned, I actually second what sir is saying that, though you have very meticulously prepared everything and there was nothing which you missed out on. So many congratulations for that. But yes, just be a little more modest. When you're presenting your case, just have a more smiling face, so it becomes relatively pleasing. But it's a tough call. Trust me, it's very difficult. I think for us also to take this decision. So, but all the best, and may the best team win.
We'll make sure that we make a note of it, ma'am. Thank you so much
No,
again.
but
And now
wonderfully
we're actually
done.
laughing.
Yeah, now you can laugh. It's all over. The stress is
Yeah.
all
Your lordship,
gone.
are we able to like put our points and like are you like satisfied for our like arguments?
Yeah, yeah,
Are we
most certainly. As I told you that, unofficially, I think your job was more tough. But
exactly
please,
right? I have been
yes.
researching for months like for this.
But please keep
Uh,
certain things on your fingertips, particularly the basic
indeed,
provisions of the Constitution, okay?
indeed,
Those
indeed.
should not be missed out on. And another thing, of course, we had to discuss the constitutionality of 498A, etc. But I think you focus too much on its criticism. Okay, you should have been more into justifying how it is not invoked in your case. All right. So I think
Thank you so
that's
much,
about
ma'am,
it.
again.
Thank you so
I
much.
mean, I think we did not have a smiling face for a matter of fact because this is the first time that we are participating in a moot court
Oh, if it is
competition.
your
Also,
first time, then you were really,
yes.
really good.
Thank you,
So
ma'am.
we were
Yeah,
like,
please keep
Indeed,
up the
ma'am.
good work.
once we qualified the quarterfinals, you're like, okay, we have 1 hour round up, let's get it done.
Same,
So
ma'am,
we like
same.
really stressed out. So that could be one of the possible reasons.
No,
But
no,
yeah, we'll
but
make sure that next time we have this huge smiling faces.
no, many congratulations to all of you. Trust me, it's very difficult to take a decision. Both
Thank
of
you
you
so
were
much.
very good. Yeah.
So,
Thank you.
And,
Thanks,
for the
sir.
defendants, I think what the petitioners have missed out on, all the points were there with you intact. As I said, you did not miss out on anything.
Thank you, ma'am. Thank you, sir.
Yeah, even they have mentioned case laws on diaries. How diaries are admissible as a dying declaration.
So I
Thank you
think,
so much.
yeah, all the best to all of you. Have a bright future ahead. And can you all exit with the permission of the organizer so that me and sir
yes,
can
yes,
discuss and give you the marks?
yes,
Yes.
yes.
In your
Yes.
lordship.
Yeah, best of luck,
Okay.
guys. Bye bye.
Thank
Have
you
a
so
good
much,
day.
ma'am. Thank you so
Thank you,
much,
ma'am.
sir.
Thank you so
And
much.
you, all of you were really good. Okay, so take that confidence along.
Thank you, ma'am. Thank you, sir.
Okay,
Thank you.
okay. Bye bye. Bye.
Well,
Participants,